In this video, we'll look at recent groundbreaking developments in the world of law and artificial intelligence that have the potential to shape the way technology is used in our justice system. Our story begins with a federal lawsuit, Mata versus Avianca Inc. Plaintiff Roberto Mata sued Colombian airline Avianca Inc. for injuries that he sustained on an airplane when a flight attendant struck his leg with a metal serving cart. The defendant filed a motion to dismiss Mr. Mata's personal injury claim. The plaintiff's lawyer filed a response with the court, arguing that the court should not dismiss his client, Mr. Mata's injury claim. So here is the plaintiff's response in question. And as you can see here, I have highlighted some case law the plaintiff has cited in support. There's nothing unusual about this. This looks perfectly legitimate. Here is another case. And of course, you see here in various other instances, the plaintiff is citing these cases and explaining what they stand for. The first sign of trouble in this case for the plaintiff's attorney occurred when the defendant filed their standard reply. So here is the defendant airline company's reply. It states that although plaintiff ostensibly cites to a variety of cases in opposition to this motion, the undersigned has been unable to locate most of the case law cited in plaintiff's affirmation in opposition. And the few cases which the undersigned has been able to locate do not stand for the propositions for which they are cited. On the next page, the defendant blows the whistle on all of these citations being totally fake. The undersigned has not been able to locate this quotation, nor anything like it in any case. So needless to say, after reading the defendant's reply and they're pointing out to the judge that, hey, these citations, these cases, they don't exist. U.S. District Judge Kevin Cast was probably furious. No doubt that after reading the defendant's reply brief, the judge had his law clerks try to locate the cases in question. Once his clerks confirmed that they could not find the cases cited by the plaintiff's attorney, the judge issued an order to the plaintiff's attorney. So here we have the judge's order on April 11th. It says the plaintiff's attorney here of record shall file an affidavit, that means a sworn written statement under oath, attaching copies of the following cases citing in his submission to this court. Points out 9 different cases, actually 8 cases here. The first one being the Varghese versus China Southern Airlines company that we looked at, and various other cases that are under suspicion at this point. Fast forward to April 25th, the plaintiff's attorney did in fact file an affidavit with the ostensible cited cases attached to it. He says that pursuant to the court order, I have annexed, that means attached, copies of the following cases previously cited to his affidavit. He attaches at least the Varghese case and the others that I have marked right there. And interestingly, the notary here was none other than Stephen Schwartz. Pay attention to that name because it'll become relevant later in this video. So here is the ostensible opinion in Susan Varghese versus China Southern Airline Co. Limited. This is super fishy. It doesn't even have page numbers, but this is what the attorney attached to their affidavit as the Varghese case. This blows my mind, but needless to say, we later will discover this is a totally fake case. This is not real. This is not an opinion. They are trying to pass this off now to the court as a real, actual opinion when they know at this point it's not. Then on May 4th, the judge slammed the gavel down on the plaintiff's attorney, issuing an order to show cause to the attorney that no attorney wants to see. Let's see what the judge had to say. It states, the court is presented with an unprecedented circumstance. A submission filed by plaintiff's counsel in opposition to a motion to dismiss is replete with citations to non-existent cases. The court issued orders requiring plaintiff's counsel to provide an affidavit annexing copies of certain judicial opinions of courts of record cited in his submission, and he has complied. Just one problem. 6 of the submitted cases appear to be bogus judicial decisions with bogus quotes and bogus internal citations. The clerk of the United States Court of Appeals for the 11th Circuit, in response to this court's inquiry, has confirmed that there has been no such case before the 11th Circuit with a party named Varghese or Varghese at any time since 2010. That is the commencement of that court's present electronic certification filing system. The court goes on to say the bogus Varghese decision contains internal citation and quotes, which in turn are non-existent. The court goes on to state down here that the following 5 decisions submitted by plaintiff's counsel contain similar deficiencies and appear to be fake as well. Let counsel for plaintiff show cause in person at noon on June 8 and explain why he should not be sanctioned for citing non-existent cases and submitting to the court, annexed to his affidavit filed April 25th, copies of non-existent judicial opinions. So then May 25th rolls around, and as the hearing approached, the lead plaintiff's counsel in this case probably realized he had to do something. He had to throw a Hail Mary before the June 8th hearing. So on May 25th, LaDuca filed an affidavit in which he sheds light on what was actually going on here. He states in his sworn statement, this matter was assigned to Stephen Schwartz, an attorney with this law firm right here. He goes on to say that he did not personally conduct any of the legal research involved in the drafting of the affirmation in opposition in question, nor did he have personal knowledge of how the same was conducted. Your affiant had no reason to doubt the sincerity of Mr. Schwartz's research. He will obviously be a witness in the forthcoming hearing to explain the basis of his research and how he located the cited cases. Your affiant has attached an affidavit prepared by Mr. Schwartz representing the information that will be presented at the hearing and which offers an explanation of the research performed. Now let's look at Stephen Schwartz's affidavit explaining what happened, what he did. He says that as the use of generative artificial intelligence has evolved within law firms, your affiant consulted the artificial intelligence website ChatGPT in order to supplement the legal research performed. It was in consultation with the generative artificial intelligence website ChatGPT that your affiant did locate and cite the following cases in the affirmation in opposition submitted, which this court has found to be non-existent. In other words, totally made up. He says the citations and opinions in question were provided by ChatGPT, which also provided its legal source and assured the reliability of its contents. Excerpts from the queries presented and responses provided are attached here too. Stephen says that he has never utilized ChatGPT as a source for conducting legal research and therefore was unaware of the possibility that its contents could be false. He says, this is my fault. He accepts responsibility in not confirming the sources provided by ChatGPT. He greatly regrets having used generative artificial intelligence and will never do so in the future without absolute verification of its authenticity. And then finally, we see the excerpts of chat conversations that this attorney had with ChatGPT. He says, here is Varghese a real case? And then ChatGPT replies matter-of-factly, yes, it is a real case. And then he says, what is your source? And ChatGPT says, I apologize for the confusion. Upon double checking, I found that the case, and then cites it, does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. Those are the big 2 legal research databases that most lawyers use. I apologize for any inconvenience or confusion my earlier responses may have caused. Well, this, it turns out too, is a bald-faced lie by ChatGPT, just trying to cover its tracks, I guess. Are the other cases you provided fake? And ChatGPT says, no, the other cases I provided are real and can be found in reputable legal databases such as LexisNexis and Westlaw. And so I found this conversation hilarious because it's just so absurd. It reminded me of a parent catching a child telling a lie, and instead of fessing up to the lie, the child audaciously tries to cover up their behavior with more lies, with even less believable lies. And that seems like what is going on here. Like, ChatGPT, did you give me fake cases? And ChatGPT, like many children might do in the similar situation, denies it. The whole thing is absurd. If ChatGPT fabricated a case once, why would you expect a different result from these prompts? Another note that I made was that these prompts were clearly not the original prompts that the attorney entered to find these cases. I would be curious to see what that attorney entered into ChatGPT to get the case law that he cited in that response. My guess is that he might have typed something like, can you find me cases that support an argument for X, Y, and Z? And then ChatGPT comes back with these cases. Maybe he did several follow-up prompts where he's asking ChatGPT, can you clarify what those cases said? What was the holding and how did they support my client's case? That raises all kinds of ethical questions, but if I had to guess, I would say that is what the attorney did. And then notably, the attorney's affidavit does not try to explain or excuse the fact that he filed with the court completely fabricated legal opinions to try to conceal the non-existent cases, including this one, the Varghese case. I really thought the cover up here was worse than the underlying offense, because the attorney could have come clean and said, yes, Your Honor, I admit that these cases were made up. I used ChatGPT. It was definitely an oversight, a mistake, and I apologize. It'll never happen again. But instead, the attorney brazenly tried to keep that a secret by attaching these fake cases that are clearly not legitimate legal opinions after the court's suspicion had already been raised. It just blows my mind that they did that in that April 25th affidavit. In any case, the judge was apparently not impressed by the affidavits filed by the plaintiff's attorneys, because the following day he issued a revised order to show cause, stating that attorney Peter LaDuca should also prepare to explain at the hearing why he should not be sanctioned for filing a false and fraudulent notarization in his April 25th affidavit. Pause this video and go back to look at the signature page of that affidavit, and you will in fact see that it was this other attorney, Stephen Schwartz, the one who used ChatGPT, who served as the notary in Peter LaDuca's affidavit there, which it's just the whole scenario is unbelievable to me. The court also pointed out that the attorney's affidavits still did not address the fact that they had filed fabricated opinions in an apparent cover-up attempt. So they've got a lot of explaining to do at that hearing on June 8th. Federal judges across the country are no doubt paying close attention to this case as it unfolds. It's easy to see how this could happen in any court across the United States. With the sudden rise of ChatGPT and generative AI tools, it's no surprise that attorneys are going to try to use these to make their job easier and more efficient. To avoid something like this from playing out, one federal judge has developed the first ever AI certification policy for attorneys who appear in his courtroom. On May 30th, Judge Brantley Starr of the U.S. District Court for the Northern District of Texas, my home district, announced on his official webpage that he would begin to require attorneys appearing in his court to sign what some have called a generative AI pledge at the beginning of a lawsuit. Let's look at the judge's explanation for this rule right now. Right here, you can see at the top of the webpage, and this is his official webpage, he explains that all attorneys appearing before the court must file on the docket a certificate attesting either that no portion of the filing was drafted by generative AI, such as, and then he lists ChatGPT and several others, or that if attorneys do decide to use ChatGPT or other generative AI tools, that they checked every single citation and statement of law for accuracy using print reporters or traditional legal databases like Westlaw or LexisNexis by a human being, not simply by asking the chatbot, is this a real case? Judge Starr explains that these platforms are incredibly powerful and have many uses in the law: form divorces, discovery requests, suggested errors in documents, anticipated questions at oral argument. I've even heard of CEOs at big companies using ChatGPT to help them prepare and anticipate for deposition questions. But legal briefing is not one of them. Here's why. These platforms in their current states are prone to hallucinations and bias. On hallucinations, they make stuff up, even quotes and citations, as we just saw. Another issue is reliability or bias. While attorneys swear an oath to set aside their personal prejudices, biases, and beliefs to faithfully uphold the law and represent their clients as advocates, generative artificial intelligence is the product of programming devised by humans who did not have to swear such an oath. As such, these systems hold no allegiance to any client, the rule of law, or the laws and Constitution of the United States, or, as addressed above, the truth. Unbound by any sense of duty, honor, or justice, such programs act according to computer code rather than conviction, based on programming rather than principle. Any party believing a platform has the requisite accuracy and reliability for legal briefing may move for leave, and that's permission, and explain why. Accordingly, the court will strike any filing from an attorney who fails to file a certificate on the docket attesting that the attorney has read the court's judge-specific requirements and understands that he or she will be held responsible under Rule 11. That's the sanctions rule that allows courts to sanction attorneys for misconduct for the contents of any filing that he or she signs and submits to the court, regardless of whether generative artificial intelligence drafted any portion of that filing. And then you can see here, the judge offers a link to a model certificate that has this AI pledge in it. So what are my key takeaways from this, and what are the future implications that this whole incident has on the use of AI in the practice of law? Well, first, this incident clearly demonstrates that there is a major demand among attorneys for a reliable version of ChatGPT or some other tool that can perform legal research and writing for lawyers without fear of hallucinations. I can understand why a lawyer would want to use ChatGPT to do their legal research. It's time consuming, and sometimes it feels like looking for a needle in a haystack when you're spending hours and hours looking for that one case that supports an argument that you want to make, that you know is out there, but you cannot for the life of you find it. Attorneys who represent plaintiffs in, for example, personal injury cases, as in the Mata case that we just discussed, are paid a percentage of whatever they recover, whenever they recover that. They don't get paid by the hour, and therefore they cannot afford to spend countless unpaid hours researching for cases and drafting extensive, lengthy legal analysis. Even defense lawyers who are in fact paid by the hour and therefore have every incentive to be as thorough as possible when doing legal research and to have actual human lawyers doing that so that they can bill for it and get paid. Clients on the defense side, they complain when they get a hefty legal bill for legal research. So in other words, there is clearly a market for a reliable generative AI tool that can perform legal research without having to have a human double check all of the work product, which essentially eliminates the efficiency of using AI in the first place. You might as well just have a human do it without using the AI tool. That being said, as this incident demonstrates, lawyers should absolutely not rely on ChatGPT in its current form to perform legal research and writing. The most reliable research tools are still Lexis and Westlaw, and they are working on AI tools as we speak, similar to ChatGPT. Third, I would not be surprised if more courts across the country roll out similar certification requirements as news of this story spreads across the court system. Finally, you might be wondering what is going to happen to the lawyers involved in the ChatGPT fake case law scandal that we just learned about. Will they have to pay a huge fine? Will they be suspended from the practice of law? Could they even lose their law license? Well, the court will probably decide those questions and hear arguments on them on June 8th at the show cause hearing. So make sure to hit that subscribe button below and turn the bell notification icon on if you don't want to miss any updates on this developing story and all other stories involving the clash between artificial intelligence and our conventional legal system. And of course, as always, thanks for watching.